All right, here we go. So a little bit about our firm. Higher Gutierrez, we're a relatively new firm, but we have significant experience representing school districts and local educational agencies. For myself, I started working with school districts on the legal side of things as soon as I left law school, and that's what I've been doing for almost 10 years at this point. Today, we're going to be talking about the use of AI and specifically using AI to record IEP meetings. And if you have any questions, please use the Q&A function as well. So part of this too is that that CSBA, I've heard, is going to develop model AI policies perhaps this summer. The AI recording tools can be very useful because it's a way to quickly find if you have a recording of an hour, 2 hours. Sometimes these IEP meetings go quite long, as you all know, and these recording apps allow you to find a specific point in the transcript. And this also has been discussed as a legal issue in terms of privacy law. It's OAH, for example, has issued a categorical ban on attorneys using AI to record their proceedings. And there's also been a number of guidance issued from various sources, from public agencies as well as private law firms. And what I really want to focus today also is really more of a technical analysis of what AI tools to use and how to use them. Because I think the guidance that's been issued to date has been missing a little bit of that real deeper technical analysis when considering the privacy implications. And we'll talk about how that is really an important thing to keep in mind, because there's certain AI tools that implicate privacy protections in FERPA and EDCODE, and there's certain AI tools that don't. So I just want to start with a disclaimer as well, and this is a disclaimer that we have with all our presentations, but it's worth repeating again. So the materials in this slide and the recommendations, the conclusions that we have in this presentation are general and they're not legal advice. And so the reason for that is that if you look at privacy law, there's always very small distinctions on what is the app you're using, how does it work, what is the contract like, and there's also further points like what is your local agency's policy, what disclosures have you made to families in your district regarding privacy. So if you want specific legal advice for your situation in your district, it's going to depend on those details. So today we're just going to be talking a little more in generalities and making some general assumptions about the technology you use and the systems that you have in place. So in the spirit of giving practical advice, solution-focused representation is our motto at HG. This is kind of our roadmap for today. And we have a very, very important and critical distinction that we'll be talking about in this half hour, which is the on-device AI versus the cloud-based AI. And this is the distinction that makes all the difference if you're talking about privacy laws. Because when you talk about privacy laws, you have to look at FERPA and EDCODE, which talk about where you keep information and who has access to that information. Whereas AI is really just how you process that information. So the critical piece is, where are you doing the processing? Are you doing that, so to speak, in your own house, or are you doing that as a third party doing that for you? And so what I think a lot of the AI guidance has been missing is consideration of the fact that nowadays, and for the last couple of years really, there have been personal devices like phones and computers that have had the possibility of doing on-device AI processing. And so if the processing is happening on your computer or on your phone, you're not sharing that data with a third party. And so a lot of the privacy protections then don't even come into play. And so that's why I say that if you're doing on-device AI with a work device, that's the safest way to go. And chances are that is not going to get you in trouble when it comes to these privacy protections that exist in the law. If you're using cloud-based AI, I'm not saying that it's compliant or non-compliant. There are cloud-based solutions that market themselves as being FERPA compliant. And these these cloud-based solutions, you have to really look at it individually, because there are those that are FERPA compliant and those that aren't. So, and if you're using a personal device, there's a little question mark too. And this is why I'm saying the cloud-based AI, it's not a thumbs up, it's not a thumbs down, it's just question marks, because there's more questions raised in terms of privacy when your information is going out to a third party. So when I say using AI to record IEPs or record IEP meetings, what do I mean and how does this work? So apps can either directly record the meeting audio, or you can import an audio file for processing and interaction. And so the benefit of this is that there's a transcript that's created by the LLM. So this is a machine created transcript. You can then search that transcript, like you can search a particular word, find it in the recording, and go to the spot in the audio recording where that is. So if you have, a 2-hour IEP team meeting, it saves you a ton of time to do this. And myself, I've used this in OAH proceedings before OAH said it wasn't allowed, of course, and it saved me a lot of time. And it's also really helped me understand what happened better, because you can really pull out and find specific points of discussion and quotes in your recording. And a lot of these AI features also have a summary tool where you can see a summary of what was discussed in any particular meeting. So if you're a case manager, if you're a psych, this also has the potential to save you time and to make things more accurate in the IEP process, or if you're trying to summarize a meeting for whatever purpose. If you have a dispute about what was discussed or not discussed at an IEP team meeting, you want to go back in the recording and find it exactly. It's going to be a lot easier if you're using AI tools than if you just have one big 2-hour block of audio that you need to sift through. So let's talk a little bit more about the type of AI recording apps and the technical considerations. So cloud-based and on-device AI solutions. So this is really the $1 million distinction here that we want to make on the technical side. So on-device solutions, they perform data processing locally, so on your device, so the data never actually leaves your device. Cloud-based solutions, you're uploading that data into the cloud, and you're relying on remote servers for storage and processing. There are examples of on-device transcription, and this is why I think this recording is so important to keep in mind, because the newer iPhones, the newer Samsung Galaxy phones, they all have on-device recording transcription features. And so these are things that work without an internet connection, and the data never actually gets shared with the third party, but you still have the benefit of using the transcription features and a lot of what I mentioned with AI. Now, one of the differences I will say is that obviously if you're sending that recording off to a server farm off who knows where, then you have those computers, that processing is more powerful than what your phone or computer can do. So maybe there's a little bit better quality to the cloud-based option, but having used the device-based option myself, it's probably still good enough to give you a lot of the benefits that you're looking for out of an AI-based solution. So how do you know whether you're using something online or offline? So if you're not too tech savvy, of course, school districts, you all have IT departments. You can ask them for help. Is this a device-based AI processing? Is it a cloud-based AI processing? But here's a couple things you can do to figure that out really easily. So you can test your apps offline. So if you're on a phone, put your phone in airplane mode. It's not connected to the internet. If the transcription feature still works offline, and I tested this on my phone, if the transcription feature still works offline, then what that means is that this is running on the device and not in the cloud. And a lot of times the device-based solutions will be free because you're not using anybody else's processing power, you're using your own device. And the ones that charge a subscription price are going to be the cloud-based options, because then they have the costs, of course, of running their servers and data centers or whatever off somewhere. So let's talk about, now that we've talked about the technical side of things a little bit, let's talk about the legal considerations for recording IEP team meetings. So talking about recording meetings generally, so school districts cannot unilaterally record an IEP team meeting if a parent objects. So this is Ed Code 56341.1G. And this provides that a parent has a right to audio record an IEP team meeting if they provide 24-hour notice. The LEA, if the LEA wants to unilaterally record, the LEA also has to provide the 24-hour notice, but then the parent gets to veto the LEA recording. So the parent has a right to record. The LEA can only record if the parent records or if the parent gives consent to record. And so outside of the IEP process, you have a general prohibition in the penal code about recording confidential communications. And so confidential communication is going to cover pretty much any conversation between school staff and parents. So it could be, a 504 meeting, an SST meeting, a parent-teacher conference, an informal conversation in the principal's office, things like that. Penal Code 632 would apply. And so in that case, a party is not allowed to record a confidential communication without the consent of all involved. So if you are allowed to record an IEP meeting and you do the recording, what then are the privacy laws that apply to such recordings? So the definition of a pupil record is any information directly related to the student maintained by the school district. And so these are terms of art, and so the definitions are not what people always expect them to be. So for example, there's case law, SA versus Tulare County, where a federal court actually determined that emails about a student are not student records unless they're printed and placed in that student's file. So this second prong of something being maintained by the school district is really a term of art, and it's often a kind of a counterintuitive definition for people. There's also data maintenance responsibilities. So Ed Code, for pupil records, Ed Code has various contracting requirements. And for example, and these are in Ed Code 49073.1. And so it says that contracts have to include, and then there's a whole laundry list of things that a contract for storage of pupil records has to include. There's also requirements that there be some privacy and security measures for pupil records. So let's talk about FERPA. And so there's a distinction between FERPA and Ed Code and what they cover. So Ed Code covers pupil records. FERPA covers PII, or personally identifiable information. So potentially there could be things like internal emails about a student that are not pupil records, but still contain PII. And so therefore those would still be covered by FERPA, but not necessarily all of the Ed Code requirements about storing pupil records. So audio recordings of an IEP are under the Ed Code automatically subject to FERPA protections. It's not totally clear whether an audio recording on a personal device, for example, would be considered a pupil record such that the Ed Code protections would apply. But as we'll get into it on the legal side, there's a lot of things that aren't clear about privacy and privacy guidance as it pertains to AI and digital technology generally. So using personal devices is another question mark in terms of FERPA. So SPPO, which is the office that interprets FERPA, has a letter that they issued in 2020 that states that we have not issued formal guidance on the use of personal devices by school officials, nor do the regulations in FERPA specifically address the issue. And so again, you might have local policies in your school district or expectations in your departments about using personal devices. This is just what the law is, and so there might be further requirements locally that you have, but FERPA doesn't directly address whether you can or cannot use personal devices to store PII. So let's talk about US DOE guidance and data security. So some of this is where your information is kept is regulated, where student information is kept, but also how you keep it is regulated to some extent as well. So FERPA, again, same office, SPPO, has said that there is no requirement to adopt specific security controls, but the U.S. Department of Ed has said that local educational agencies, or really anyone storing student information, has to take appropriate steps to safeguard student records. and cautioning that if records are kept in a way that is not secure, that could lead to a violation of FERPA. And so the US Department of Ed has what's called a data security checklist. It was last updated in 2015. So as you can imagine, it doesn't talk about AI at all, but still there are some takeaways that we want to go through and that are relevant to IP meeting recordings, because of course that recording is going to have to be stored somewhere. Usually people are using phones to record IP meetings. So here's some relevant recommendations or requirements from the US DOE data security checklist. Data encryption, encrypted data transmission, and device level security measures. And this all sounds very complex, but I guarantee you probably all of you have a personal device that, whether you know it or not, complies with all of these things. Both Android and iOS phones, for example, have had encryption as the default setting on for a long, long time. If you are using a work email account or a work Google Drive type of thing to move files from one place to the other, that's almost certainly going to be compliant with FERPA requirements, because we send each other IEPs like that all the time, of course. Device level security measures, so strong passwords. So for example, if you have Face ID or fingerprint on your phone, that's going to be compliant with US DOE checklist. And if you have like a screen lock timeout type of thing, like if your phone is on and it's not used for 2 or 3 minutes, the screen will lock and then you have to log back in with your fingerprint or something like that. That's a really common default setting for phones. And so chances are that your work device, I'm sure if it's set up by IT, it's probably compliant with FERPA. And even if you don't realize it, probably your personal devices are compliant with the US DOE security checklist as well. So US DOE also issued an FAQ on cloud computing. And so cloud computing is when a third party handles your data. And so again, this is guidance from 2015. So it doesn't really address AI directly. But it still has some relevant takeaways. And so there are requirements that states must use reasonable methods in their IT to safely handle and store information. And there's this requirement here: the outside party may not use or allow access to PII except in accordance with the requirements established by the educational agency. And so where this really comes into play with AI primarily is that how is the data being used to train the large language model? So a lot of the AI services just that I've looked at that are cloud-based, they say that they de-identify your data, and they don't really explain what this is or how it works. So it takes maybe a little level of trust in the company to trust what de-identifying data actually means. And it still is a legal gray area, because you see the term in FERPA as personally identifiable information. So if it's de-identified, arguably it's not PII anymore, but what does it actually mean to de-identify data? And the relevant guidance that we have here on cloud computing is from 2015. So it doesn't even contemplate the concept of LLMs or AI or data de-identification at all. So that's really, again, when we go back to the chart that we had at the start, that's why we have those question marks for cloud computing, because we really don't know very well how it's going to be interpreted from a privacy perspective. So service agreements, there's also requirements for service agreements with a third party handling PII. The third party must perform a service typically handled by employees. The district must have control over records, and a service agreement has to ensure that third parties don't misuse data or allow unauthorized access. And so this is all going to be highly situation specific. Again, that's why I didn't put a thumbs down or a thumbs up for cloud-based AI. I just put the question marks. Your agreements with a third party may be compliant with this, or they may not be compliant with this. There are third-party solutions, cloud-based solutions out there that represent themselves as being FERPA or HIPAA compliant. So those might be compliant, in fact, and maybe it is a good idea to use those, but it's going to be a really case-specific situation where you want to see how they are compliant and whether you want to take that step. And again, right on, if you're using on-device AI tools that don't go into the cloud, you never even get into this question of service agreements and third-party requirements, because the data is staying at home on your device. So these are some big questions I have still that haven't been fully resolved by law and guidance. So is it a pupil record if you're using a personal device to record an IEP meeting? How does it apply to cloud-based recordings? What about de-identifying information? Does that still make it PII if it's used in an LLM? We also have to apply guidance and records from 2015 or earlier to now 2026 when we're using AI. And then what happens if AI generates a transcript? Is that an education record? All of these questions haven't been fully addressed by privacy guidance by the US Department of Ed. So let's close out here. We have a few minutes left. Let's close out here with the implications for parents and staff. So one related question is, can parents use AI apps to record IEP meetings? And so this actually was addressed a few months ago in a CDE compliance complaint. And specifically what happened in this situation is that the advocate wanted to use an AI app, I think it was Otter AI specifically in this case, to record an IEP team meeting. The district and the IEP team did not allow that because of privacy concerns, what would happen. And so the advocate filed a compliance complaint with CDE saying they should be allowed to use AI apps to record IEP meetings. And CDE found the district out of compliance. And now it's possible the district may have asked for reconsideration with CDE. I haven't heard that this has been overturned. But if you have parents and advocates using AI apps to record this is just one more thing to keep in mind. You might ask, well, what about FERPA? FERPA usually applies to how educational agencies store their information, so it wouldn't really apply so much to what a parent does with the recording of an IEP meeting, and that maybe was CDE's logic behind this. But the key takeaway is that CDE said parents can use whatever AI app they want to record IEP team meetings. And so when we close out here, we're going back to the matrix that we started at the start of our presentation. So if you're using a work device and you're using a on-device AI solution like the voice memo transcription in iOS or the transcript assist on Samsung Galaxy devices on the newer ones, if the recording and the processing happens on your own device, not in the cloud, you're going to not even get into a lot of the implications of FERPA and third-party records and all of these things. So you're dealing with a much, much easier universe than in terms of privacy compliance. If you're using cloud-based AI solutions, it's possible. There are solutions that say they are compliant. It's possible that they are compliant. You just have a lot more questions that you have to answer in terms of can you do this and how can you do this and how are they storing their records? All of these things, the questions get a lot more complicated when you're using the cloud versus an on-device solution. And I'm a big fan of these recording apps. I know everybody is so busy in special education. We have high caseloads. Everyone's working really hard. So anything you can do to make people's life easier, I think is a positive. And I think AI represents an opportunity if we use the tools correctly to use technology to really make our lives easier, to synthesize information. And we know we have a fire hose of information and data when it comes to special education. And so if we can use technology to process that a little bit to help us in our work, it's, I think, a wonderful tool, a wonderful opportunity for school districts, but we have to use it the right way. And we have to keep in mind that there are certain legal requirements, both in Ed Code and FERPA, that also protect what is happening with student data. So we have some upcoming events as well. If you find our Lunch with Legal series informative, we have some events coming up. So this right here was a special edition Lunch with Legal. We just focused on this topic because this is something that was really interesting to me and that I wanted to share with you all in light of AI board policies and the constant discussion around AI that's been happening. But our regular Lunch with Legal events are about OAH cases, and we go over the newest OAH cases. So if you want to stay fresh on all the OAH cases that have come out in January of 2026, we have a QR code right here, or go to our website, jairgutierrez.com/events. Register for our Lunch with Legal on February 27th, 2026 to go over the January cases. And if you like our training series, we do in-person trainings as well. We have a really interesting training coming up on the Delta King. It's going to be the afternoon of March 27th. The Delta King, if you don't know, is a big boat, big paddle boat steamer on the Sacramento River in Old Town Sacramento. It's going to be a great event. We'll go into topics into a little more depth than what we do on these short Lunch with Legal webinars, and we really hope to see you there. Again, I want to reiterate for those that didn't catch it at the start, these presentations are not legal advice, so there's a lot of particular distinctions and nuances that need to be considered before giving legal advice to any specific situation. So I really encourage you to speak to an attorney if you want to get legal advice about your specific situation and whether you can use AI apps. We're just kind of talking in generalities and general assumptions here. We also would love if you connect with us online as well, Instagram, LinkedIn, our website. We also have a YouTube channel where we post the recordings of these Lunch with Legals. So if you missed our prior events, head over to YouTube and you'll see the recordings of that as well. Otherwise, thank you all so much for joining us. Please, if you have any questions about the subject, AI recordings, please don't hesitate to send me an email, give us a call. We would love to talk to you more about this, and we hope to see you at our future events as well.